What is the difference between federal and state workplace regulations? In today's rapidly changing work environment, understanding the difference between federal and state workplace regulations is more important than ever. Just yesterday, many employees and employers were seeking clarity on how these regulations impact their rights and responsibilities. If you are wondering how these laws affect your workplace, you are not alone. Federal regulations set nationwide standards that all employers must follow. This includes laws such as the Fair Labor Standards Act, the Family and Medical Leave Act, the Occupational Safety and Health Act, and equal employment opportunity laws. These laws create a baseline for employee rights and employer obligations across the country. On the other hand, state regulations apply only within each state. They can offer more protective measures than federal laws. For instance, some states have established higher minimum wage rates or additional paid leave requirements. This means that if a state has a higher minimum wage than the federal standard, employers must comply with the state law. When federal and state laws differ, employers typically must follow the law that benefits the employee more. This is particularly relevant for minimum wage and overtime rules. While federal law sets a minimum wage, many states have opted for higher rates. Paid leave is another area where state laws can offer more than federal provisions. Some states requiring paid sick leave or family leave that goes beyond what the Family and Medical Leave Act mandates. Employment protections can also vary significantly. Some states provide broader anti-discrimination coverage, protecting additional groups that may not be covered under federal law. For employers with remote or multi-state employees, compliance can get more complicated. Employers must adhere to the laws of the state where the employee performs their work. For example, if a remote employee is located in a state with paid sick leave laws, those laws apply even if the employer is based in a different state. The Family and Medical Leave Act has specific criteria that apply to employers with 50 or more employees within a 75-mile radius of the employee's worksite. However, state family and medical leave laws may have different eligibility requirements. When hiring employees in a new state, businesses may need to register for tax and employment purposes specific to that state. Additionally, each state has its own new hire reporting requirements, workers' compensation rules, and unemployment insurance regulations. In summary, federal workplace regulations provide a foundation for employee rights, while state regulations can add additional protections. Employers must navigate both sets of laws carefully, ensuring they comply with whichever standard is more beneficial to employees. Understanding these differences is essential for anyone involved in the workforce today.